In a landmark judgment affirming the rights of land occupants, South Africa's Constitutional Court has unanimously dismissed an appeal to overturn a ruling on the crucial right to graze cattle. The case centered on whether a landowner can prohibit long-term residents from keeping and grazing livestock on his property. The Apex Court's ruling reinforces that the right to use land encompasses more than mere residence and includes, for example, small-scale farming and cattle rearing. Let's speak now about this with Professor Ruth Hall, Director at the Institute for Poverty, Land and Agrarian Studies at the University of the Western Cape. Professor, thank you for your time. I think the first question is, beyond the specific right to graze, what is the broader constitutional significance of this judgment?
Thanks, Veronica. So what the court says is that in a case such as this, where people have had a right that they have been granted, there's been consent to graze cattle. That consent was held by the mother of the three brothers who brought this case. She passed away. They continued to graze the cattle in the same way that she had during her lifetime, and that the owner cannot then, without any cause or without any due process, remove that right. So a very important point here is that it could easily be misinterpreted that the court is saying every farm worker has the right to keep cattle. And the court does not say that. In fact, it didn't say yes or no. That was not the question that was being answered here. What it does say is that where consent has been granted for people to use land, not just to live on, but to use it for a variety of purposes, then that occupier, under the law, under the Extension of Security of Tenure Act, which governs the rights of people living on farms, those rights cannot be taken away without a due process. So what it refers to here is not just where express consent was given, because these three brothers didn't get consent from the owner, but their mother had had that consent. And on her passing, they continued to exercise that right, and there was no action taken against them. And then after some years, the owner said, no, you cannot. So what this case turned on is whether tacit consent, implied consent, constitutes a right under the law. And the answer is yes. And I think that the important point here is that what the court took into account is that this is a law that was passed in 1997 specifically to regulate the highly unequal power relations between people who own private property and people who live on it. And that in interpreting it, the law, that it should be generously interpreted with the purpose of understanding that people who have very little, who are relying on access to land that has been granted at some point in the past, need the protection of the law, that those rights cannot be simply taken away. So I think this is a really significant judgment. The remarkable thing is that this court case that has gone through the Land Claims Court, firstly in 2022, then through the Supreme Court of Appeal, and now at the beginning of August, a judgment from the Constitutional Court, turned on the question of whether three brothers have the right to graze 5 cattle on a farm.
Yeah.
And the court said, and all the courts have now declared, they do have that right. It cannot be taken away from them. In fact, if it were to be taken away from them, it would be tantamount to an eviction, because it would be an unlawful removal of a right to use property.
And let's talk a little bit about those rights. I know that the court also emphasized the link between grazing rights and, of course, human dignity. Can you elaborate perhaps on the legal reasoning behind this connection and how it strengthens, of course, the position of vulnerable tenants?
Yeah, so this turns on a clause within the Constitution. Section 25 is the property clause in the Constitution. And the subsection 25(6) specifically deals with the situation, well, it sets out that people who have insecure rights to land as a result of past racial discrimination are entitled to secure rights. So that part of the Constitution frames all the legislation around people's tenure rights. And so the way in which this was being interpreted is understanding that land dispossession and the fact that some people hold more powerful rights to property than others has a particular history in our country. And the drafters of the Constitution made it clear that this is about racial injustice. And I think that what's crucial here is that dispossession is not only about being dispossessed of a house or a home, but a whole range of things. And this is also reflected in our other land reform legislation, like restitution. It's clear that dispossession involves a loss of homes, but also a loss of place, of identity, of access to graves, of access to grazing land, of a place of dignity, of social connections. And what we see in many parts of South Africa is that people who've lived on farms for many generations on land that belongs to others actually have that as their home. That is home. And so what we have in reality, and what needs to be understood at a level of law, is that we have different sets of competing property rights on the same land. And what this court case then does is that it shows that private property is not an absolute, that anyone who owns property, that the rights that they have to that property are circumscribed and limited by other people's rights, including the public. There are bylaws and so on. But any property on which non-owners have traditional use rights, those use rights need to be protected. And I think that it's very significant here that grazing is specifically recognized. Very large numbers of farm workers, farm dwellers around the country have supplemented their livelihoods through keeping their own livestock, through farming on a small scale. And what this judgment does is it recognizes that constitutes a right in law. It cannot be taken away without due process. And importantly, the owner's argument that as an owner they should have the right to remove an entitlement to graze, that right does not exist, that actually any removal of a property right would need to go through a careful process, and that process has to weigh up the potential harm to the owner and the potential harm to the occupiers and users of the land. So, this is a complex area, but what it clearly sends a message is that property rights are not absolute. Yeah. People who are long-term users and occupiers of land do have property rights. And that we need to understand it in a historical context, and that those who use their rights and maintain using their rights are more likely to be able to defend them.
Yeah, certainly, Professor. And I think this judgment in itself comes at a very crucial time where the conversation of land is definitely thriving in terms of the discourse in society. But could this ruling be setting somewhat of a tone as well for other similar cases involving the interpretation of the right to use land, specifically under ESTA, and perhaps for other agricultural activities?
Well, I think that, the court was actually asked two questions by the applicants. So these are the three brothers who approached the Constitutional Court to overturn the Supreme Court of Appeal. The first request was, please rule that, in fact, we do have this right, that we as occupiers of a private farm, people who occupy that land with the consent of the owner, that we also have a right to graze cattle. And that would have had far more wide-ranging implications if the court had ruled on that. The second request was recognize that we had de facto tacit consent. So the court said, we will not rule on the question of whether all farm occupiers have a right to graze. And the court said, actually, that would be a better case to come before the Land Claims Court, for the Land Claims Court to rule on that, and then for that case perhaps to be referred there. And I have no doubt that such a case will come. I think that people around the country who are desperate with the fact that we haven't really dealt with land inequality and land injustice are increasingly turning to the courts. We do have a revamped land court, which is super. It seems that they're dealing more rapidly with cases. And I think that people around the country are trying to see what can be achieved through legal means. Just today in Cape Town, I've been at an event called the Urban Land Justice Gathering, where people around cities have been talking about land injustice in the cities. And again, the demand is not only for housing. It's for access to land to keep livestock on the edges of the city, to have access to places for recreation, for public space. I think that the pressure is on in terms of land, and it's partly because of the unequal way in which our cities and countryside are still structured. Effectively, the fact that our land reform program has wound down and didn't go terribly far, and the fact that we have a housing crisis. So across both urban and rural sectors, I think we can see that people are trying to use the legal mechanisms that do exist to try and engage and push both private property owners and the state to wring out concessions. But as I say, this is a case that has wound down for some years. It is a very specific kind of demand, but it nonetheless sends a very clear message, which is people who are non-owners, who have traditional rights, that they have had the consent of owners to use land in certain ways, not only to live there, but to use for grazing, for cultivation, or other traditional purposes, cannot simply have those rights removed. Those constitute a form of property right for non-owners. And I think that that's a profound point that is entirely in line with the ethos of the Constitution.
Yeah, certainly a landmark ruling then, definitely bringing the conversation back again in regards to land reform. That is Professor Ruth Hall, Director for the Institute for Poverty, Land and Agrarian Studies at the University of the Western Cape.